Chief Election Commissioner of India, Shri Rajiv Kumar ji, is all set to retire on February of 2025. Now, this has brought back the focus before the Supreme Court on Wednesday, January 8th, 2025, the need to fast-track a decision on the legality of a new law dealing with the appointment of election commissioners and chief election commissioner in our country, which gives central government a dominant role, a dominant hand in the selection procedure of the election commissioners. Now, Justice Suryakant, heading a 3-judges bench of Justice Dipankar Datta and Justice K.V. Vishwanathan, has highlighted that the test regarding the validity of Chief Election Commissioner and Election Commission of India Act 2023, the validity of this act would hinge and depend upon whether the court's authority to pronounce binding decisions under Article 141 of our Constitution can be circumvented or diluted by legislative procedure or by a law. That whether a judgment given by the Constitution Bench of Supreme Court of India can be circumvented or diluted by a law in our country or not. That is by the act of a parliament or not. Who supersedes who? That is the real question which we are talking about. Now, the petitions in question, there is a very pivotal question that whether the parliament, it possesses the authority to pass a gazetted notification, to pass a law or an ordinance to nullify or amend Constitution Bench judgment or not. Whether the union government, whether the central government or the parliament is having a power to do so or not, that is the question which is put forward. And the petitioners, including an NGO, Association for Democratic Reforms, and activist Jaya Thakur, they have claimed that the law which was introduced, this election commissioner, chief election commissioner and election commissioner law of 2023, was introduced in December 2023 to dilute a constitution bench judgment of the Supreme Court in the Anup Baranwal case on March 2, 2023. Is the act correct or not? And will that act stand the test of constitution or not? Now, these petitions, they have primarily challenged one section of this act, that is section 7 subsection 1. Now, this section 7 subsection 1, it mandates the President of India to appoint chief election commissioner and election commissioners on the basis of recommendations of a selection committee. And that selection committee would comprise of your Prime Minister of India, second, the leader of opposition in Lok Sabha, and third, a cabinet member, a cabinet minister to be decided by the Prime Minister. So that is a cabinet minister nominated by the Prime Minister. These three would be a part of the selection committee who will then be recommending that who will be the chief election commissioner and election commissioners to the President of India, who then will be appointing them. And this is according to the Act. And under the Act, there is section 7 subsection 1 which talks about this. However, the Honorable Supreme Court of India's judgment, it says otherwise. It says, and it has directed that the Chief Election Commissioner and the election commissioners to be appointed by the President of India on the basis of a selection committee, but that selection committee will comprise of 3 members, which will be Prime Minister of India, second will be the leader of opposition in Lok Sabha, and third will be the Chief Justice of India. And there is no mention of a cabinet minister to be the part of the selection committee. But in the act which was introduced and passed by the Parliament of India in 2023, in that act, Chief Justice of India is not present under the selection committee. And who is present? A cabinet minister. But what did Honorable Supreme Court of India say? That there should be Chief Justice of India who should be a part of this selection committee, who would be recommending Chief Election Commissioners and Election Commissioners to the President of India. Now, the Constitution Bench, when they gave the judgment, they explained that the committee should be of diverse heads. It was very necessary to protect the fierce independence, neutrality and honesty of such a big institution such as Election Commission of India, and to end the government's monopoly and exclusive control over the appointments to the highest poll body in our country. That was the motive and that was the pronouncement which was given by the Supreme Court. But months later, a very big change happened. A law got enacted in the Parliament and it got passed by the Parliament, and it replaced the Chief Justice of India from the selection committee with a cabinet member, which basically gives government an upper hand in the appointment of Chief Election Commissioner and election commissioners. Because cabinet minister and Prime Minister both are the part of the government. And then the third member is the leader of opposition. Now, many legal experts, they have called out this move of the central government and the legislature, and they have called this new act as a threat to Indian democracy and a blatant disregard of the judgment given by the top court, that is Supreme Court of our country. Now, what is the actual issue all about? What is Election Commission of India and why it is so important for our country, for the democratic processes of our country? All these things we'll be trying to understand in this particular session. Hello, my name is Preetpal Singh and you are watching Perspective. So bench of Justice Suryakant, Dipankar Datta and Ujjwala Bhuvian was informed by the advocate Prashant Dhawan, representing an NGO, that the incumbent Chief Election Commissioner Rajiv Kumar is all set to superannuate on February of 18th. And a new Chief Election Commissioner would be appointed under the new law if the court does not intervene. This was what was told to the court by Advocate Prashant Bhushan. Now the bench has posted a hearing on this matter on February 4th and has said that they would see that whose views are having supremacy. Now the bench has said that it will be the opinion of the court under Article 141 of the Constitution versus the legislative power of the Parliament to enact a law. So it will be a competition between that and who is supreme. Also, this is not the first time where this law has been challenged. On March 15th, 2024 as well, the Honorable Supreme Court of India has refused to put a stay on the appointments of various election commissioners under this 2023 Act. So earlier they have refused to put a stay, the Supreme Court of India. And at that point of time, the court has told the petitioners that their 2023 judgment was that the three members should be comprising of Prime Minister, Leader of Opposition and Chief Justice of India until a new law is framed. So this had to be operated till Parliament makes a new law on this. That is what Honorable Supreme Court of India said in 2024 when this act was challenged. However, Advocate Prashant Bhushan, who is appearing for Association for Democratic Reforms, he has challenged the Chief Justice of India's exclusion and has contended that Election Commission should be insulated from any political pressures, from any executive interferences for maintaining a healthy democracy. This is what he has to say around this issue. Now coming to the judgment which Supreme Court of India made. Now at that point of time, the Constitution bench, they drew its reasoning or their reasoning from Article 324 of the Constitution, which gives the superintendence, direction and control of elections to be vested in an election commission. Also, Mr. Shankar Narayanan has said that the government cannot take control over the appointment of election commissioners through a law. For that to happen, a constitution amendment needs to be passed by the Parliament. This is what he has to say. And now we all know that the contention is between who supersedes whom. Whether the direction given by the Supreme Court of India is supreme, that is opinion given by Honorable Supreme Court of India under Article 141, that is supreme, or the law enacted by the Parliament, that is supreme. Now that is the real question, answer to which we will be getting in the next few weeks. But till then, it is very important for us to understand why Election Commission of India is so important for us. See, as we all know, that Election Commission of India is an autonomous constitutional authority, which is responsible for administering union and state election processes in India. Now, it was formed or established according to the Constitution on 25th of January 1950, which is also celebrated as National Voters' Day. And the secretariat of this commission is in New Delhi. Now, as we all know that this body, it administers election to Lok Sabha, to Rajya Sabha, to state legislative assemblies in India, and also to the offices of President and Vice President in India. Also, one interesting thing to note here is that it is not concerned with the elections to panchayats and municipalities. For that, we have separate state election commissions as part of the Constitution of India. And talking about the Constitution, there are different constitutional provisions which guides the functioning and powers of the Election Commission. So in our Constitution, Part 15, that is from Article 324 to 329, it talks about the election machinery in our country. So it deals with elections and establishes a commission for these matters. And there is one article, that is Article 324. Now, it deals with the superintendence, direction and control of elections to be vested in a election commission. So this is from this article, Election Commission of India is formed. Now, Article 325, it says that no person to be ineligible for inclusion in or to claim to be included in a special electoral roll on grounds of religion, race, caste or sex. That is Article 325. Now, there is Article 326, which says election to the houses of the people and to the legislative assemblies of the states needs to be based on universal suffrage. And then there is Article 327, which says that the power of the Parliament to make provisions with respect to elections to the legislature. And then there is Article 327, which deals with the power of the Parliament to make provisions with respect to the elections to legislatures in our country. And after that, there is Article 328, which states about the powers of the legislature of the state to make provisions with respect to election to such legislature. And at last, there is Article 329, which bars the interference of courts in electoral matters. And definitely there are exceptions to it, as we all know. Now, since it's very clear that Election Commission of India is formulated through the Constitution of India, now let us know its structure. So originally Election Commission of India had just one election commissioner. But after the Election Commissioner Amendment Act of 1989, it was made into a multi-member body. So Election Commission of India currently should comprise of one Chief Election Commissioner and such number of other election commissioners, if any, as President may determine from time to time. Now presently there is one Chief Election Commissioner and two Election Commissioners of India. Now coming to appointment and tenures of the commissioners. Now the President appoints Chief Election Commissioner and Election Commissioners as per the CEC and Election Commission Act of 2023, which we earlier saw. And as per the Act, both of them, that is Election Commissioners and Chief Election Commissioner, will be appointed by the President on the basis of a selection committee. And that selection committee currently on the basis of the Act comprises of Prime Minister of India, Leader of Opposition in Lok Sabha, and third is a Cabinet Minister who is nominated by the Prime Minister. And the recommendations of the Selection Commission, they are valid even after there is a vacancy in the committee. Now to aid the Selection Committee, there is a search committee which is headed by the Cabinet Secretary of India, and it suggests 5 names to the Selection Committee. But the Selection Committee is not bound by any of these names, and they can consider any other person as well which has not been suggested by the Search Committee. Also, an important thing to note here is that Election Commissioners and Chief Election Commissioner, they have a fixed tenure of 6 years or up to the age of 65 years of age for them, whichever is earlier. And the salaries and the service conditions of the Chief Election Commissioner and Election Commissioners will be equivalent to that of Supreme Court judge. And now coming to the most important part, removal. Now, the Chief Election Commissioner and the Election Commissioners, they can resign anytime or can be removed even before their expiry of the terms. So coming to the Chief Election Commissioner can be removed through the office only through a process of removal which has to be followed when the removal of a Supreme Court judge is happening. So similar to the removal of a Supreme Court judge, the removal of Chief Election Commissioner will happen. And this happens through Parliament of our country. But Election Commissioners can only be removed on the recommendations of Chief Election Commissioner of India. So for both of them, the procedure is different. And now coming to the most important part, that is functions and jurisdictions. So what are the functions and jurisdictions of Election Commission of India? See, first is that it is having an advisory role. So Election Commission of India, it advises the President or Governor on any matter related to disqualification of members of Parliament and state legislatures, especially in cases involving corrupt electoral processes. So one advisory role is played by the Election Commission of India. Now second is a quasi-judicial role. Now Election Commission of India can also disqualify candidates for failing to submit election expense accounts and resolve disputes. So they are having the power to resolve disputes as well regarding the recognition of political parties and the allocation of election symbols, which we have seen recently in the last many years. And above all, they have a very big administrative role as well. That is, they handle the delimitation of constituencies, they handle voter registration, they handle updation of electoral rolls, they handle scheduling of election dates, and above all, it also ensures the adherence to Model Code of Conduct. And the whole election machinery of India during the time of elections, it is controlled, administered by the Election Commission of India. Now, to assist Election Commission of India in all this regard, there is a very extensive electoral machinery which works into play or which comes into play. And to support the electoral processes, below the Election Commission of India, that is Chief Election Commissioner and Election Commissioners, there is Deputy Election Commissioners also, which are drawn from the civil services of the country and are appointed by the Election Commissioner of India with a tenure system. And all of them, they are assisted by secretaries, joint secretaries, deputy secretaries, and under secretaries as well. So that is first, that is Deputy Election Commissioners. And next, there is Chief Electoral Officer, that is CEO. And after this, there is Chief Electoral Officer, that is CEO. The CEO, they are appointed at a state level, and the Chief Election Commissioner in consultation with the state government. So that is CEO. And below CEO, there are District Returning Officers. So one is the CEO. Below them, there are District Returning Officers, DROs. And these officers, they are appointed at district levels. Now, the collector of the district acts as a DRO for every constituency in the district in most of the cases. So one is the CEO Below that, it is the DRO. CU is at the state level, DRO is at a district level. And below DRO, there are returning officers. Now, returning officers are appointed by the DRO for every constituency. So DRO in turn, they appoint the returning officers. And below returning officer, there is a presiding officer. These officers are appointed by DRO for every polling booth. So for every polling booth, there is a presiding officer. Presiding officer reports to the returning officer. Returning officer reports to the district returning officer, DRO. And DRO reports to the CO, Chief Electoral Officer. And Chief Electoral Officer in turn reports to the Election Commission of India. And this is how the extensive election machinery of our country works. Now, since we have had a fair bit of understanding and discussion about the Election Commission of India, its functions, controversies, let us very quickly see what are the real issues which are plaguing the election or electoral reforms in our country and which Election Commission of India should look towards and should try to solve immediately. See, first very big issue is that of political interference. See, if political interference is there in the Election Commission, definitely the electoral procedure cannot be transparent, cannot be open and cannot be free and fair. And for a democracy like India, it is essential, quintessential for elections to be free and fair and trustable so that it remains credible and the public confidence on the electoral procedure and electoral process does not go away. Which is why political interference needs to be stopped, needs to be reduced as much as possible in Election Commission of India's appointments. And most of these appointments, almost all the appointments, should be done on a neutral basis and on the basis of merit. But that is the first problem. Now, second issue is in relation to limited powers. Now, Election Commission of India's power to impose certain decisions and punish offenders is many times limited. This hinders its ability to effectively implement regulations and ensure compliances with the electoral laws. Which is why this also needs to be corrected. Now, third very big issue is in relation to electoral fraud and malpractices. Now, the challenge for controlling electoral fraud and malpractices in different polling stations, polling booths, it is very difficult for Election Commission of India to manage. Of course, after coming of e-technology and e-governance, Election Commission of India has been able to make the systems more robust and make the systems unhackable, so that the EVM machines, they cannot be hacked and the other electoral procedures, they cannot be hijacked by untowards authorities or by the authorities which are non-state. So that is the third challenge. Also, there is a very big technological challenge and gap also. Definitely, Election Commission of India is trying to incorporate artificial intelligence, trying to incorporate Industrial Revolution 4.0's things into this, but there is a long way to go. We need to integrate technology, we need to integrate all the cutting edge technologies which are available currently to ensure that the elections in our country, they remain free and fair and also they remain efficient and effective as well, so that the democracy could be made more vibrant. And the last amongst the many challenge, how they tackle disinformation and fake news. So we already see during elections that there is a lot of disinformation and fake news in our TV media, in our news media and in our social media as well. And because of that, it creates a lot of recklessness and also a lot of moral policing and a lot of unjust creatures who are roaming in the streets and taking decisions based on the fake news. Which is why it is very important that this needs to be tackled and to ensure that there is fact check of each and every news which is published in relation to the election. Otherwise, it should not be published. It should be fact checked first and then it needs to be published. And extreme opinions needs to be curtailed, which can influence the mentality of the public and the public confidence on the system. And amongst all these things, definitely urgent reforms is the need of the hour and is the requirement to correct all these problems. See, we all know that Election Commission of India stands as the bulwark of our democracy and ensuring the sanctity of the electoral processes and upholding the democratic ideals which are enshrined in our constitution is the most important thing for priority on the government and for us as well. And reforms, if implemented, needs to be implemented collectively. And this will help in modernizing the electoral system in our country, addressing all the loopholes, addressing long-standing issues of transparency and accountability during the elections, and also to restore public faith in India's democracy. Because public faith is the most important thing which makes Indian democracy go higher and make Indian democracy even more vibrant. Now, while some of these proposed reforms, they require constitutional amendments, others can be achieved through a legislative procedure or legislative action and administrative changes as well. What is required at the most is process reform. Process needs to be reformed and then it will be ensured that the eventual goal will be achieved. The tiny processes, which on the face of it might look very tiny, but they have huge ramifications. So changes in processes is the need of the hour. And also, key to successful reform implementation, it always lies in bipartisan consensus. It also lies in robust public engagement, engaging the public, and the commitment of the government, political parties, and the election commission to uphold the integrity of the electoral process in our country. If that is there and bipartisan consensus can be achieved, definitely the reforms are not far. And the electoral process in our country can be made the best in the world. I hope you gained some insight from this lecture. Do let me know what are your views surrounding this issue and whose side is supreme or whose side is having more weight in the comment section. I'll be very happy to read your comments. All the very best and have a beautiful day. Thank you.